Office of the Public Defender. People do not believe that any conflict exists. Make a waiver for the avoidance of all doubt.
Thank you.
Good morning.
Ms. Perry.
Assistant Public Defender Lauren Kearney. The Public Defender's Office likewise does not believe this. This one does, we also believe.
All right, the court for its part also does not believe there's a conflict either in the Michigan court rules or the cases decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matter. Am I waiting?
That's who I was calling.
I'm not going to talk to you
You're not gonna talk to me.
unless you have good.
I'm asking for a really quick thing, but.
Denied. Court calls the case People versus Benjamin Coleman.
Alexander on behalf of the people.
Good morning.
Good morning.
Sherilyn Foster Tucker on behalf of Benjamin Coleman.
Benjamin Coleman.
In your honor, today's date time set for final settlement conference. At this time, the people are unable to proceed.
Motion to dismiss.
All right. People being unable to proceed, this case is dismissed. That's without prejudice. Thank you.
Thank you, Your Honor.
Thank you. And can you come here for a moment? I need to talk to you.
I know. Don't be surprised.
Okay. Court does call the case People versus Adika Skib.
Ashley Lonnie for the people.
Kyle Burrell on behalf of Annika Skib, who's approaching the podium and will be standing to my right. Ms. Skib, once you get up here, please introduce yourself to the court.
My name is Annika Skib.
And we're this morning for final settlement. That said, people are unable to proceed.
Defense moves to dismiss.
People being unable to proceed, this case is dismissed. That's without prejudice.
Thank you, Your Honor.
Ms. Skib has a tether on. Will she be able to go by today, or does she have to wait till tomorrow to go get the tether off from community corrections?
Keep it.
What do you think?
As much as I'm attached to it, Your Honor.
Literally.
Or it attached to you, right? She should be able to go over and get it taken off once they know that the case is dismissed. So before you leave here, you can turn your friend back in. Right?
Thank you, Judge.
Here. Court does call the case of the People versus Stephen Watson.
Alexander on behalf of the people, Your Honor.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Watson, who stands to my right. Please state your name for the record, sir.
Stephen Watson.
In your honor, today's date time set for final settlement conference. At this time, the people are unable to proceed.
Motion to dismiss.
People being unable to proceed, this case is dismissed. That's without prejudice.
Thank you, Your Honor.
Thank you. Court calls the case People versus Deontay Arnold.
Alexander on behalf of the people, Your Honor.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Arnold, who stands to my right. Please state your name for the record, sir.
Deontay Arnold.
In your honor, today's the date time set for final settlement conference. At this time, the people are unable to proceed.
Motion to dismiss.
People being unable to proceed, this case is dismissed. That's without prejudice. All right. Thank you.
Thank you, Your Honor.
Okay.
Oh, you're good.
Court calls the case People versus Nicole Caldwell.
Ashley Lonnie for the people.
Not yet, no.
Assistant Public Defender Natalie Pate with and on behalf of Ms. Caldwell, who stands to my right. Please state your name for the record, ma'am.
Nicole Caldwell. We are set for final settlement. This time, the people are unable to proceed.
Motion to dismiss.
People being unable to proceed, this case is dismissed. That is without prejudice.
Thank you.
Thank you.
Thank you, Your Honor.
Court calls the case People versus Spencer Chambers.
Alexander on behalf of the people, Your Honor.
Good afternoon, Assistant Public. Good morning, Assistant Public Defender Lauren Kearney.
You were doing that all day yesterday.
I know I was.
I don't know what, and then when it got to afternoon, you said good morning, and then you.
I know. I don't know where I am, what time it is.
Oh, that lends itself to confidence. Go ahead.
Well, Your Honor, my client's not here. I did speak with him this morning. He lives in Lansing and does not have a car or transportation. So he could not be here. He was here in person for his last pre-trial. For the record, I would request an adjournment of the final settlement conference as the people cannot proceed on this case.
Your Honor, I would ask for a bench warrant. This isn't his first issue here.
It is not, it is his third. And then having failed to appear, bench warrant will issue. Bond will be setting him at $25,000. I'll give a 10% privilege on that. That warrant will issue immediately. Court does call the case of the people versus Haley Force.
Eshelani for the people.
Assistant Public Defender Natalie Pate on behalf of Ms. Force, Your Honor, who unfortunately I do not believe is present. Our office did successfully make contact with her earlier this week and advised her this court date. I reached out to her again yesterday. Unfortunately, it was unsuccessful speaking with her. I do not have an explanation for her failure to appear, but for the record, I would respectfully request an adjournment of this final settlement conference.
Bench warrant will issue for defendant's failure to appear. Bond is setting him at $25,000.
Bless you.
I will give a 10% privilege on that. That warrant will issue immediately.
Thank you, Your Honor.
Your Honor, I apologize.
25,000.
1,000%. Thank you.
Court does call the case of the people versus Daniel Sims.
Eshelani for the people.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Sims, who stands to my right. Please state your name for the record, sir.
Daniel Sims.
And Your Honor, we have reached a resolution in this case in exchange for a plea to an added count 2 of retail fraud in the 3rd degree, a 93-day misdemeanor, $500 fine or triple amount, contrary to MCL 570-356E4. That being retail fraud in the 3rd degree, retail fraud in the 2nd degree, currently charged count 1 will be dismissed.
That is correct, Your Honor, and that is what Mr. Sims would like to accept today. I do have the paperwork with me, the assigned advice of rights form. I do have the police report if the court would entertain a no contest plea. But I do understand the tardiness of the police report.
Pardon?
I do understand I am turning in the police report tardily.
Yeah, is he going to plead guilty or no contest? You know,
He was asking to plead no contest, Your Honor.
pardon?
It don't matter either which way, I guess.
He does he is fine to plead guilty, Your Honor. He's ready to
whichever
proceed either
makes it
way.
easier.
Let's have him sworn.
You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes,
Go ahead, lower your hands, state your name.
Daniel Sims.
All right, sir, it is this court's understanding you're going to plead guilty to the charge of retail fraud in the 3rd degree. It is
Yes,
a misdemeanor punishable by up to 93 days jail, $500 fine plus court costs. The fine could be increased 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. Do you understand that?
yes,
And understanding that, do you still wish to plead guilty?
yes,
And to that charge, how do you plead?
guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yep,
Yes?
yes, I'm sorry.
You signed an advice of rights form, is that correct?
Yes,
Any questions regarding any of those rights?
no,
Look at paragraph 5. You see a copy on the podium. Those are your rights, which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
yes,
You understand you're giving up your right to appeal of right.
yes.
Are you on probation or parole?
I am now.
Okay.
I
Fair
am now.
Fair enough. At the time of this offense, were you on probation or parole?
No,
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
no,
Has anybody threatened you or coerced you? in any way?
no,
You're doing this voluntarily
yes,
of your own free will
yes,
and because you believe that you are indeed guilty?
yes,
August 10th, 2024, at the location of the TJ Maxx store on Carpenter Road. Yes, at 3158 Carpenter Road, Pittsfield Township, Washtenaw County, State of Michigan. What did you do on that date that makes you think that you're guilty?
I walked out the store with a backpack.
Okay, so you went into the store, correct?
Yes,
And you took a backpack
yes,
and you walked out without paying for it?
yes,
The store was open to the public at the time?
yes.
You didn't have anybody's permission to take that property, did you?
No,
And this backpack that you took was backpack that was offered for sale by TJ Maxx?
yes,
Counsel, have I complied with the court rule? Would it be proper to accept this defendant's?
Your Honor, it was more than just a backpack. There were other items as well, but if the defendant will stipulate to the amount of restitution being $249.86, I don't have an issue with the factual basis.
I believe it would be proper to accept this court's plea, Your Honor.
Yeah.
Yes, and we
Yeah.
would stipulate to that amount.
Court will accept the defendant's plea to count two. Count one is dismissed. Defendant is referred to probation for a pre-sentence investigation and report and determination of restitution. Sentencing in this matter will be
June 25th at 9 a.m.
June 25th, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you. Court calls the case People versus DeQuan Hardwick.
Ally's on behalf of the people, Your Honor.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Hardrick, who is approaching the podium. Please state your name for the record, sir.
Daquan Hardrick.
In your Honor, today's date, time set for final settlement conference. At this time, the people are unable to proceed.
Motion to dismiss.
People being unable to proceed, this case is dismissed. That is without prejudice.
Thank you, Your Honor.
Court calls the case of the People versus Cyan Taylor.
Ashley Lundy for the people.
Good morning, Assistant Public Defender Lauren Perny on behalf of Ms. Taylor. Ms. Taylor, please state your name for the record.
Cyan Taylor.
Your Honor, we are set this morning for final settlement conference and 10 people are unable to proceed.
Move to dismiss.
People being unable to proceed, this case is dismissed. That is without prejudice. You want to keep your tether or you?
No, sir.
No?
No,
You sure?
I'm positive.
It looks great though.
No, I don't feel good.
All right. You heard my instructions. Probably
Thank you.
go over there and get it taken up. Thank you.
Thank you.
Court does call the case. People versus Elizabeth Wilson.
Ashley Lundy for the people.
Good morning, Your Honor. Attorney Michael Kelly, P77187, on behalf of Ms. Wilson, who's present, stating the right. Your name?
Elizabeth Wilson.
All right, you're good. All right.
Your Honor, today is the date time set for final settlement conference. People are able to proceed. I understand that the defendant is going to be accepting the original offer of pleading guilty as charged with a prosecutor's deferred sentence. I'm sorry, she'll be pleading no contest if the court will allow. The police report I sent over this morning, I do apologize for the lateness, but that is something that we could not avoid, I think, in this case. So that is our request today for the plea.
That's correct, Your Honor.
You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and so help you God.
I do.
Go ahead and lower your hand, state your name again.
Elizabeth Wilson.
She signed an advice originally.
She did, Your Honor. At our arraignment?
She signed a new one.
I do not believe so, Your Honor.
I don't have, I do. That she signed on December 11th, 2024. Does she recall signing that?
Do you recall when you originally signed this document with me at your arraignment?
Did I? I don't know.
You did. I don't know. And we also discussed.
Well, I'll pass it. She needs some rights and then I'll call you back up.
Yep.
Sorry.
Court calls case People versus Jarrell Davis.
Ashley Lundy for the people.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Davis, who stands to my right. Please state your name for the record, sir.
Jarrell Davis.
Thank you, Your Honor. There is a resolution in this matter to which my client will be pleading to added count 2 of allowing an ineligible person to drive, and in exchange, count 1 will be dismissed. I do have a signed advice of rights form here.
And it is my understanding that Mr. Davis will be getting his license back next week, which is part of the reason for this reduction.
Yes, that is correct. And he did show me that paperwork from the Secretary of State that he is eligible and all his other holds have been
And this
lifted.
is not going to abstract to mess that up.
It will not. Allowing an ineligible person to drive is not. No ops on a person, I believe, does, Your Honor.
Seven sworn.
Raise your right hand. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
Go ahead and lower your hand, state your name.
Gerald Davis.
All right. Sir, it is this court's understanding that you are going to plead guilty to the charge of allowing an ineligible driver to operate a motor vehicle. That's a misdemeanor punishable by up to 90 days, $100 fine plus court costs. You understand?
Yes,
Understanding that, you still wish to plead guilty?
yes,
And to that charge, how do you plead?
guilty.
And you understand by pleading guilty, you'll not have a trial of any kind.
Yes,
All right, you signed an advice of rights form today, is that correct?
yes,
Any question about those rights?
No.
Please look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that.
yes,
You understand you're giving up your right to appeal of right.
yes,
Are you on probation or parole?
No.
Anybody promise you anything to get you to plead guilty to this charge other than what's been stated here today?
no,
Anybody threaten you or coerce?
no,
You're doing this voluntarily
yes,
of your own free will
yes,
and because you believe that you're guilty?
yes,
Yeah, okay. On the date of May 27th, 2022, at the location of US 23 Famous Road in Pittsfield Township, Washington County, State of Michigan, did you have custody or control of a motor vehicle?
yes,
Did you allow someone who was otherwise ineligible to operate that motor vehicle, maybe inclusive of yourself?
yes,
All right, counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
People are satisfied.
Yes, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Anything you want to tell me before I impose sentence?
no, I'm ready to get this taken care of.
And you get your license back?
Yeah, I was supposed, it would have been Sunday the 8th, but I gotta wait till the 9th because it's on the Sunday.
Because it's on a Sunday.
So I gotta wait till Monday morning.
So how'd you get here? No, don't answer. Don't even, I'm not, I don't want to know. All right. I'll suspend 90 days in jail, fines and costs of $250. When do you think you can get that paid?
Next week.
Next week? All right, just get it paid 20th. Give me
Okay.
next week on that, all right? June 20th. All right.
Thank
Good
you.
luck to you. Drive safe, eh?
Thank you, sir.
Court does call the case, People versus Jada Taylor.
Ashley Lonnie for the people.
Good morning, Assistant Public Defender Lauren Perny on behalf of Ms. Taylor. Ms. Taylor, please state your name.
Hi, Jada Taylor.
Hello.
Your Honor, today is the date set for final settlement conference. The witness from Walmart was here earlier, Mr. Wright, and the defendant has elected to plead guilty as charged with sentencing under HIDA.
That is correct, Your Honor. She will accept that offer, and she did sign an advice of rights form.
That's sentencing under HIDA.
Yes, Your Honor.
All right. And Ms. Taylor sworn.
You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Go ahead and lower your hand and say your name again.
Jada Taylor.
All right. Ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of embezzlement by an agent or trustee, 200 to 1,000.
Yes.
That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that?
Yes.
Understanding all of that, do you still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Yes.
Well, and to that charge, how do you plead? Guilty?
Oh,
Not
guilty. Sorry.
How do you plead?
Guilty.
All right. You understand that by pleading guilty, you'll not have a trial of any kind.
Yes. I
You
understand.
signed an advice of rights form, is that correct? Any question regarding any of those rights?
No.
Look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record?
No. Nope.
Anybody threaten you or coerce?
No.
You're doing this voluntarily
Yes.
of your own free will
Yeah.
and because you believe that you are indeed guilty of this offense?
Yes.
June 9th, 2022, at the location of 7,000 East Michigan Avenue, that being the Walmart. Were you an employee of Walmart?
Yes, I was.
All right. What'd you do that makes you think that you're guilty?
I was an employee of Walmart and I was ringing up gift cards.
You were,
Ringing up gift cards.
okay. You were a cashier?
Yes.
All right.
I was a customer service representative.
Okay. And you were ringing up gift cards?
Yes.
Explain to me, what do you mean you're ringing up gift cards?
I were loading gift cards. Loading gift cards.
You were loading gift cards. And when you were loading these gift cards, was somebody giving you money to load onto those gift cards?
No.
All right. What was your intent to do with those gift cards then?
Purchase stuff for my child.
Okay. Fair enough. You were going to keep those gift cards and then use them to purchase items from the store.
Yes.
All right. And at no time regarding those gift cards did you supply the money that was the sort of the backing for those gift cards, correct?
Mm.
You came into possession of those gift cards as well as had the ability to load those gift cards by virtue of the fact that you were employed at Walmart. Is that correct? And nobody from Walmart gave you permission,
No.
correct?
Yes, that's correct.
And the amount in total that you loaded onto these gift cards, was that in excess of $200?
Yes.
All right. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
The people are satisfied. Satisfied, Your Honor.
Court will accept the defendant's plea of guilty to this charge. Defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be July 9th, 2025, 9 a.m. Bond will be.
Thank you. Your
Thank
Honor.
you.
What am I calling? Court calls the case of the people versus Elizabeth Wilson.
Ashamani for the people.
Michael Kelly, P77187, on behalf of Ms. Wilson, who's present, standing to my right. State your name for the record, please.
Elizabeth Wilson.
Did I have her sworn already? Pardon? Okay, all right. All right, you have been sworn, and ma'am, it's this court's understanding that you are going to be pleading no contest to the charge of malicious destruction of personal property less than $200. That is a misdemeanor punishable by up to 93 days of jail, $500 fine plus court costs. The fine could be increased 3 times the value of the property by $500. That would become the maximum fine. Understand that?
Yes, sir.
All right. Do you understand what a no contest plea is?
Yes, sir.
2 things about a no contest plea I have to make sure that you understand is desirous or wanting to contest this charge. You understand that?
Yes, sir.
Second thing you need to understand is that for purposes of sentencing, the court would treat you the same as though you had pled guilty. You understand that?
Yes, sir.
Basis for the no contest plea?
The police report, Your Honor. That would be, oh, I'm sorry, oh, the base, oh, concern for prospective civil liability, Your Honor. Caught me sleeping there. I was ready for it. I was ready for it. I thought you wanted me to give this exact number. I was like, okay, okay. Proceed.
Well, thank you. My court. Appreciate you giving me permission. Ma'am?
Yes.
To that charge, how do you plead?
No contest.
You understand that by pleading no contest, you will not have a trial of any kind.
Yes, sir.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No.
Please look at paragraph 5 on that form. Those are your rights which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No,
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
no,
Anybody threaten you or coerce you?
no.
You're doing this voluntarily?
Yes.
Of your own free will?
Yes.
All right. Court has been provided and has reviewed Pittsfield Township Department of Public Safety report for their case number 23-16-502. Any objection to the court having reviewed that report?
No, Your Honor.
No objection.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court?
Satisfied.
Satisfied, Your Honor.
Court will accept the defendant's no contest plea to this charge. Defendant is referred to probation for a pre-sentence investigation and report and determination of any restitution, and prosecutors deferred. Sentencing in this matter will be July 9th, 2025, 9 a.m.
Your Honor, can I get an alternate date on that? I'm supposed to be in Rochester at 8:30 that morning.
July 23rd at 9 a.m.
That works.
July 23rd, 2025, 9 a.m.
Thank you, Your Honor.
Bless you. Bond will continue.
Thank you.
Johnson and Mac and Drukas?
And Foster Tucker.
Really?
Not me.
Andy.
And Mr. Livingston. I kind of feel about that.
I really don't want to talk to any of them.
I know. We're gonna have a good time.
All right,
We only need 5 minutes.
you always say that, and then it's a half an hour later, and I don't know what the heck is going on.
We actually are on the same page this morning.
What?
We're on the same page this morning.
Are you in the same book?
Yes, very close.
Probably right, I'll take them. Court is standing recess.
All right.
You sound like you have a plan.
Yes.
Okay. Alexis Dixon, she's in custody, huh?
Yes, there's more up front. Yeah. She's at the Plain State Jail. Ellie, you don't remember where she is?
But she's here.
Yeah, I talked to her at the jail Sunday. What did we finish on?
Plain State.
Plain State.
But they said my release date is just like the officer that brought me in. But I was released from the second from Plain State.
Okay, so your release, Plain State.
Okay, cause number 19-33599, the state of Texas versus Alexis Dixon, that's you? And you were here with your attorney and the state's attorney. What we have most recently is a third amended motion to revoke a probation. That's seldom seen here, a third amended, but nonetheless, it can happen. Are the parties ready to proceed here? Does the defendant waive a formal reading of this, and can we proceed by summons?
We're ready, Your Honor, and we can proceed by summons.
Please raise your right hand, ma'am. Do you solemnly swear or affirm any statements that you might make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, lower your hand. There's no agreement on this?
No, Your Honor, we're leaving it to discretion.
All right. This third amended motion to revoke probation in summary, ma'am, states that on June 2nd, 2021, you were sentenced to 10 years in prison, probated for 10 years for the state jail felony of theft. Now that is a higher than state jail felony punishment that you were placed on. You must have had prior convictions. I'm not, I've got to, I don't even have to look. I'll bet you pleaded true to prior convictions. Yes, I'm looking at the indictment. You pleaded true to paragraphs 2, 3, and 4, which were 2017 convictions out of Shelby County, Texas, for theft, burglary of a building and controlled substance. What happened was that state jail felony, the punishment then of the state jail felony became enhanced as though it were a third-degree felony. So you were looking at up to 10 years imprisonment. Thus, you were sentenced to 10 years in prison, probated for 10 years. Have we had hearings on this before?
You're on Ridley too.
We're just going to go to the third amended?
Well, I could explain kind of what happened.
Okay, help me out.
Are we on YouTube?
Yeah, we are, as much as we can be. Hold on.
Could you?
To build coping skills that don't have anything to do with covering up with substances. Helps me talk about things in front of people without shutting down. I actually was a peer leader. I was the senior recovery advocate there, so I talked to the other women on the microphone, and they really listened to me.
Okay.
The way I talked to them. So.
All right, so are you confident you're in a better place now?
Yes, in my mind.
You're going to make more
And I have
mature decisions that are in conformity with the law.
Yes, sir. I have a job lined up, an actual job with, Social Security taken out and things like that.
Yes, ma'am.
I have a new home to go home to. I have good family support because they believe in me. So.
All right. Okay. Well, anything else anybody wants to add?
Nothing to state here.
I'm going to find that the defendant has pleaded guilty voluntarily, knowingly, intelligently to allegation number 17, I believe, which is in the third amended motion to revoke probation, committing the offense of theft of property in Liberty County, Texas, of an amount over $30,000, but less than $150,000, occurring on or about March 21st, 2024. She has entered her plea of true voluntarily, knowingly, intelligently. That is enough to grant this third amended motion to revoke probation by a preponderance of the evidence or greater. Your probation is hereby revoked. And this court has listened to the recommendations of the attorneys and as to punishment, you are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 4 years for this state jail felony, punished though as though it was a third-degree felony because of your prior felony convictions that you pleaded true to at the time of sentencing. And the sentence shall run concurrently with other sentences. So do you understand what has well, the only other thing is, let me dot all the i's.
And there was no
Was there any
restitution, Your Honor.
restitution?
No, sir.
Okay, that's why I take care of victims. Anything else? Do you understand what has happened today?
Yes, sir.
Fix this mess that you put yourself into. You obviously know better and you have the tools to do better. So there's no excuse for failure. Failure is not an option with you. Be successful in your life. Can you?
I'm gonna give it my best shot.
No, you wanted to
Yes,
do
I
it.
can.
Everybody says, I'm gonna try,
Well, I'm gonna
but
give
you've got to get over the bar. But the bar's set low enough, everybody can. You can too. Do it.
Well, she
Just
was,
do it.
No, I don't like it. It was horrible.
All right. Anything else? That is all. Thank you. Good luck, man. Uh-oh, we need a thumbprint.
It's just an old thing. I want to make sure.
My hands are all over.
Caitlin Hicks. Hey, Rife. Rife Kimler. They're still on board. Kaylin Hicks. And then we got a bunch of yours today.
Hicks, we were going to pass that for the area, and I'll have to get home just and that's a murder trial. Good testing is the staggering.
On Kaylin Hicks, who's on that?
That's
Right,
Mr. Laird, but I'm handling it for him.
He's asking to reset this. Is that the plan? Is that what the state wants as well?
Yes.
Thank you.
Do we already have a trial?
Trial date set for July. Well, let's get these pre-trial matters, so we don't, okay. Michael Peterson.
But I have to get Dr. Holmes.
Yeah, Michael Peterson.
We'll probably should have to set that implementation back rather than stakes off.
It is.
Looks like someone.
So we've got a motion to revoke probation here in 23-153 and a new indictment in 24-530.
And she was restored to confidence.
Yes.
If we fall through here, we'll go over the big fall.
Come forward, please. How do you pronounce your first name?
Michael Raven.
Okay, but it's two names though, right? So Michael and Raven, but it's Ravine, not Ravine. It's Raven.
Yes.
Okay.
Yes, sir.
Peterson.
Yes, sir.
All right. You are here with your attorney, Mr. Kimler, and the state's attorney. And your probation officer. Here in 23 CR 153, we've got two things here. In 153, there is a first amended motion to revoke probation. That was filed on April 22nd of a year ago. And then we've got a new indictment in 24 CR 530 of a third-degree felony of harassment of a public servant that was filed, handed up by the grand jury on March 6th of 2024. And my guess is that that first amended includes that new indictment. Maybe let's see. Yeah, allegation number 3 is out of these 8 allegations of wrongdoing here. Okay, so what today? Have a hearing?
Well, I'm sure the state's, she's gonna plead untrue to the offense, and I'm sure Mr. Boyd would want an opportunity to prove that out.
That's correct, Your Honor.
Are you ready? Do you have your people today?
No, sir. I saw that it was set just to announce that she was found competent. I guess that's what I was looking
Or we'd ask the court to revisit the issue of a bond. I know her mother is desperate to have loans. Probably been, that's in the professional.
All right, I have a letter from Dr. Edgar Pond dated May 22nd, 2025, where the defendant was evaluated for competency, and the evaluation resulted in his determination that the defendant is competent to proceed to a resolution of her legal issues. I'm going to call this court's Exhibit 1, today's date. 6/6/25. And it is made a part of the record for all purposes, and we'll keep this in a sealed form. Any objection to its?
Without objection. No.
Right, is it made a part of the record for this case? The defendant, this motion to revoke probation began its journey on March 8th of 2024, when the defendant was alleged to have 5 violations of aggravated assault, resisting search, harassment of a public servant, all on February 13th, 2024 in Jefferson County, Texas, and failing to comply with program guidelines and rules of the Moral Recognition Therapy Program, which is good. It helps people make better decisions. And then failed to pay court assessed fees and was in arrears in her required payments for probation and other fees. Then a first amended motion to revoke probation came along April 22nd of 2024 and added allegations 6, 7, and 8. And it is alleged that on March 19th, 2024, which would have been about a month, a little over a month after the first 5 allegations allegedly occurred, that she committed the offense of resisting arrest or search. March 19th of 2024 in Jefferson County, Texas, committing the offense of public intoxication on that date in Jefferson County, Texas, committing the offense of injury to a disabled person also on that date. And the defendant is on deferred or unadjudicated probation for the 3rd-degree felony of injury to a child or disabled person or elderly person, and it would be what? No, talking about which of those? Elderly person.
Yeah, yes, that's her mother.
Okay. So when can we have this hearing? Soon as possible.
We can have it within a week, Your Honor.
Okay.
It shall be done. All right. Huh? 17th or 18th, y'all pick.
What day?
Today's 6th.
This 17th, I'd say.
That's gonna be week after next.
So Friday or Thursday?
It's a Wednesday. It looks like a Wednesday or
Tuesday and Wednesday.
Wednesday or Wednesday. All right, it's set for Wednesday, 17th? 18th? Okay, here is the order on the finding on Rapon. That Dr. Rapon that needs to be placed in the
Yeah.
seal envelope. And also 24CR, the new 530, the new indictment on harassment of a public servant that will roll with the motion to revoke probation. Shelby Solorendi. So it says there's gonna be a plea.
Well, that's not a plea. I'm trying to get the boss there for her to go to rehab. So, yeah, no, I think at this point, a plea would be premature. I'd like her to try to get some rehab under her belt before I dispose of it.
Well, you know, they have, we do that.
It's not.
That's a term of
It's
probation.
not a probation law. So, the state hasn't offered probation.
The state has offered probation. Senator Tim with a mandatory jail of 10 days and a $500 fine.
I'm dismissing.
Yeah.
They've offered you probation.
Yeah, y'all talk about it outside the presence of 250,000 people. So. Arlie Weaver. Hey, Ryan. You've got Arlie Weaver, 3 cases.
That's Miss Staub, isn't it?
Huh?
That's Miss Staub, isn't it?
Well, Arlie is missed up?
No, that's her case. I'm sorry. Her case is.
It says 3 cases, it says 3 cases defended to plea.
Yeah, well, I mean, it's an NTRP.
Is that what she's gonna do? I don't see it. There's nothing on the pad.
We just could,
Oh, please.
we could
And
plead,
then-
we could plead administrative.
Is that what you're gonna do?
I have an updated PSI. It just, when she gets out, I'll kind of explain the situation. This is Miss Weaver now.
Let's see, we got 1, 2, she's on 3 probation.
Yes.
Correct, Your Honor.
Okay, I don't see a new indictment. These are just 3 probations where motions to revoke probation have been filed.
Correct, Your Honor.
First amended motions to revoke probation, by the way, all filed in each of these 3 cases on March 24th, 2025. Clause numbers 23 CR 2129, 24 CR 37, and 24 CR 2001 are each called the State of Texas versus Arlie Champagne Weaver. That's you.
Yes, sir.
Present with your attorney, Mr. Kimmler, and the state's attorney. Does the defendant waive formal readings of these motions to revoke probation? Can we proceed in summary?
She does with Mayor.
Raise your right hand. Do you solemnly swear or affirm any statement you make during these hearings will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
Lower your hand. There's some similarity here on 23 CR 2129 and 24 CR 37. In summary, each of these first amended motions to revoke unadjudicated probation in these 2 cases similarly state that on February 5th, 2024, in this criminal district court, you were placed on 5 years deferred or unadjudicated probation for the state jail felonies of theft in 2129 and unauthorized use of a motor vehicle in 24 CR 37. Are those allegations true and correct as they are alleged now?
Yes, sir.
There you got 8 violations. What are we proceeding on? Did y'all talk about?
We
that?
haven't touched, I would just go through the she can have police and true or not true.
Yeah.
That's
To what?
Well, just, if you would just rate someone out the room, she can have police.
Okay. She hasn't entered any pleas prior to this, correct?
I believe that she had on 1, 2, and 3, because we held it in abeyance in October of 2024 to place her on the new probation in 24-2001.
Actually, there are no findings on any of these offenses
That's fine.
for probation. Okay. All right, so let's take them up. One, states you failed to report to the Jefferson County Probation Office for the months of April, May, June, and July of 2024. And that is similarly alleged in each of these two cases, 23 CR 2129 and 24 CR 37. And that was in violation of your probation order. Is that allegation true and correct in each of these cases? Are you pleading true and correct to that voluntarily and because those allegations are true as they are alleged? You understand that a violation proven by a preponderance of the evidence or greater of one or more violations of probation, that is enough to grant the motions to revoke probation. Probation can be revoked and you can be sentenced up to the full range of punishment in each of these cases, which sure on site that. Which are state jail felonies, not enhanced. So you're looking at, in each of these two cases, if your probation is revoked and you're sentenced, you're looking at no less than 180 days up to 2 years in the state jail. In each case, knowing that, do you insist on pleading true today?
Yes.
I find you're pleading true voluntarily. You understand and appreciate the consequences of pleading true.
Yep.
Stand by. Happen to these new substantive offenses, and looks like it's numbers 4 and 5. Assault, family violence, December 21st, 2024. Illegal possession of a controlled substance, February 17th of this year.
Is that the Orange County?
I didn't say.
It says in Jefferson County. That is not her Orange County offense. It's a Jefferson County
Yeah,
offense.
it is Jefferson County.
The assault was refused from her office. The possession is still waiting for drug results.
Okay. And let's go number 2. This alleges in each case, this violation that you failed to provide verification of performing community service hours as required in each of these two cases. Is that allegation true? Pleading true to that voluntarily and because it is true in each case. Understanding that that also has the same consequences as what we talked about in your plea of true to allegations number 1 in each case. Let's hold all of that and go to this third one, 24 CR 2001. And again, she waives a formal reading of this motion. We can proceed in summary.
She does, Your Honor.
This one was more recently filed on March 24th of 2025. And again, this states that on October 28th of 2024. You were placed on 5 years deferred or unadjudicated probation for theft of service, a state jail felony. Is that true?
True.
And allegations 3 and 4 allege that you failed to report to the Jefferson County Probation Office for the months of November and December of 2024 and January of 2025 in violation of condition 4 of your deferred adjudication order in this case. And allegation 4, you failed to provide verification performing community service hours as required in that case. Or allegations 3 and 4 in this case number 24 CR 2001. True and correct as they are alleged, and are you pleading true and correct to those voluntarily and because they are true?
Sure.
Yes. Find you're pleading true voluntarily and you admit that they are true as alleged. All right. Are there agreements on this?
No, Your Honor,
No?
just to
Go
record the
ahead.
court, she was bench warranted over here from Orange County. Judge Parkhurst in the 260th court has sentenced her to probation and ISF on new, was it theft?
Burglary of habitation.
It wasn't new.
Okay, was it older?
From that, all these crimes are committed.
There was I guess, an older burglary of a habitation case. And so she had these motions to revoke pending, so she was brought over here. She's 5 months pregnant, and it's my understanding, of course, I'm not an expert on these matters, at least on the female end, but that she has a high risk pregnancy. Again, I'm not an expert, but that's what it's been related to me. And in any case, whether it's a high risk or not, ISF won't take her. And so I'm going to have to get with the 260th of Judge Parkhurst to see how he's going to proceed on that.
How many children do you have
One.
already?
Yes.
This will be your second?
Yes, sir.
How old is your other child?
7.
Ma'am?
7.
So I don't think that ISF or safety is an option if she's continued on probation. Again, my suggestion would be, I guess, to get an updated pre-sentence report so the court could be aware of what her current situation is and how she's on obstacles that she's had while on probation before you determine whether
on these cases. Is there any restitution?
No, Your Honor.
No.
Not that I believe.
Either.
I don't believe so.
I think that I think she would benefit from inpatient rehabilitation. I think you would agree with that, is that right?
Yes.
Have you spoken to Franklin House or have you?
Yeah. Yes, sir. I was there the day before I went to court in Orange County, and I've been in jail since then.
So you put yourself into rehab?
I'm sorry, Your Honor. She was $250 restitution in 2129.
You able to pay that?
I would think her family can be able to pay that, Your Honor. I'll represent to the court.
When?
They hear anybody?
Yeah.
Would you be able to pay $250 restitution?
Excuse me, Your
There's
Honor.
also other restitution.
There's another restitution. The cost number 2001. The amount of $3,200.43. So she has 3 cases.
I understand. 2. Yeah, 2. The first 2 were when she was placed on probation on February 5th, and the third one when she was placed on probation on October 28th
Yes.
of 2024.
The total restitution is $3,000. Who's the 3,000? Who is that?
It's not written in that order, so I don't know. I don't have the old case with me.
Could we set it for sentencing? See what,
No, let's see what she has in accrued time right now, and I've got a
well, I
plan.
know the court's adamant about restitution.
I know, and they're gonna, her family can pay that first restitution. What I want to do is dispose of these two
I see.
and then keep her on.
I understand. I see where you're going.
Looks like our warrants were cleared pretty quickly, so she was in other places, but our warrants weren't.
She's got 165. So you see, you hear what, you see what I'm gonna do.
Yes, I understand.
All right. But the restitution has to be paid or I'm gonna undo it by the end of the day.
Up to 250 or?
Yeah, the 250.
250.
Yeah.
Well, hang-
Yeah, he's gonna tell you how to do it. Yes, ma'am. And we'll help you navigate through this so it can get done. Because the court has a plan here to try to whittle down these problems. Okay. All right. Anything else to add?
No, no.
Okay. Let's take up 23 CR 2129 and 24 CR 37. The court finds in each of these two cases that you have pleaded true in this first amended motion to revoke unadjudicated probation in each case voluntarily, knowingly, intelligently to allegations 1 and 2 of the motions failing to report and failing to provide verification of performing community service hours. And you have admitted that voluntarily, knowingly, intelligently, and understanding and appreciating the consequences of pleading truth to those. That is enough to grant these first amended motions to revoke unadjudicated probation by a preponderance of the evidence or greater. And the court grants these first amended motions to revoke unadjudicated probation, and your deferred or unadjudicated probation is hereby revoked by this action. In these cases, on February 5th, 2024, in each of these two cases, you pleaded guilty to theft of property, a state jail felony in 2129, and unauthorized use of a motor vehicle in 24 CR 37. You made those pleas of guilty voluntarily, knowingly, intelligently. There was sufficient evidence supporting the guilty pleas from State's Exhibit 1 admitting in each of those cases to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt in those two cases based upon these violations of probation. And you were hereby sentenced to confinement in the state jail for 180 days. That's the minimum you can get. You will be given credit for 165 so far. So you see, you've got like 2 more weeks that you have to finish out the sentence. And restitution in the amount of, was it 200? What was the amount?
$250.
$250 is ordered to be paid in the judgment, which needs to be paid on or before the end of the day so that she can be released when she finished, as soon as she can finish these 180 days. That is in the amount of $250 to the complainant in 23 CR 2129 as her name is written in this indictment. Please get with the family members so that they get the name correct when they submit it for restitution. They send it to the probation office?
Yes, sir.
Yeah, you go to the probation office, which is not far, you go a block or so from here.
I'll explain it to you.
And there's a form a form of payment that they take, and we'll do that. We'll accept that. That resolves those two cases. On this motion to revoke unadjudicated probation in 24 CR 2001, the defendant has pleaded true to allegations 3 and 4 of this motion to revoke probation voluntarily, knowingly, intelligently, and that is enough to grant this motion to revoke probation by preponderance of the evidence or greater. And these are allegations of failing to report to the probation as required and failing to provide verification of performing community service hours. Again, the court finds that is enough to grant this motion to revoke unadjudicated probation by a preponderance of the evidence or greater. Your deferred or unadjudicated probation is hereby revoked. Earlier in this case, you pleaded guilty voluntarily. You were mentally competent to do so. You understood and appreciated the consequences of pleading guilty. There was sufficient evidence supporting your guilty plea to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this state jail felony, and you are hereby sentenced to confinement in this state jail for a term of 1 year. That is suspended. You were placed on regular probation for 2 years. There will be terms and conditions of probation that you need to follow so you can get released off of that early. But we're doing this because you are going to be released here on this one. You got to just serve 15 more days on the other two to satisfy those two by law. Then you'll be released, but you'll be on probation on this. And the key thing is you got to report or else you're not on probation. You have to pay the restitution back. Quicker you pay the restitution back, get you out there, get you to get an income, be responsible, fix the messes. We all make messes. We all make mistakes. We have to fix them responsibly. That's the test for character purposes. We're helping you do your best and the best you can be. Do you understand where we are on this?
Yes, sir.
Okay. So.
Yes, no, Daniel is. Yeah.
But that restitution is owed in an amount of $2,500. Did I say 2,000 or 3,000?
It's three, Your Honor.
$3,500. But you got to get that done before the end of probation. And the quicker you get it done, the quicker that's the key to this case. When you pay restitution back, I consider releasing you early.
Yes. Thank you.
Yes, ma'am. Okay. Everybody understand where we are on this?
Yes, sir.
Okay. Any questions, ma'am?
No,
All
sir.
right. Good luck to you.
Thank you.
Good luck. I know. Well, you had to take them in
No, it's good.
installments then.
And
Yeah. It's in the invite. It's the fee for the medical that should be.
Yeah, I have a plea on Chelsea Schiff. Okay, let's do that. Yeah.
she's in custody.
Chelsea Schiff, please.
Judge, I've got it on two,
Sir.
I've got it on two defendants with murder charges that are going to be pleased.
Okay, thank you.
This is the first one. This is the first one. The second one's going to be Kadrain. Mr. Reynolds is working on that. Just keeping me in the loop about what's going on.
Javiante Fontenot, what are we going to do on that?
I have a motion to withdraw that.
Okay, that's two cases. Darren Patterson.
That we'd ask that get a reset so I can try to get that settled. Just
How long?
Just a regular reset.
3 weeks is going to be good?
Next week's.
4 weeks good? Can we do 4?
We can.
All right. Darren Patterson, cause number 24, CR 1108. Mr. Burbank is the defense attorney, is requesting recess for 4 weeks in an attempt to resolve that. And Daniel Wally.
That's the state's motion, Judge. It has something to do with
Okay.
the state's radio.
Okay. And here is Chelsea Shipp. Does she need to be sworn in? All right, 22-40128 is called the state of Texas versus Chelsea Ann Marie. Ship.
No.
That's you with Mr. Macon, your attorney and the state's attorney. Okay. This is a very serious case. They're all serious here. Some are more serious. Does the defendant waive a formal reading of this indictment and arraignment here? Can we proceed in summary?
Yes, sir.
In summary, this indictment alleges that on or about March 26, 2022, in Jefferson County, Texas, you committed the first-degree felony of murder with the use of a deadly weapon, namely a firearm, by shooting the complainant, the victim. Do you understand what you're charged with here? This is a first-degree felony, which means if convicted, you face a term of life imprisonment or any term of not more than 99 years or less than 5 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand the punishment range here, man?
Yes, sir.
And it, so.
Is it because of the writing? Judge?
Yeah.
It's 40 years, Judge.
Okay, I'm gonna redo that, Jim. I know, I wish we had this pen for everybody. This pen seems to work better on the pad
Yes,
than
sir.
others.
Thank you.
And
Thank you for clarifying.
Okay. An agreement has been reached where you would be pleading guilty, sentenced to 40 years imprisonment. Is that your understanding of the agreement, ma'am? If I follow this agreement, you have no right of appeal of your case. Do you understand? You don't have. Stand up. How do you plead to this indictment, charging you with this first degree felony, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty. I show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Did you understand it? Discuss it with Mr. Macon, your attorney? Are the contents here true and correct? State's Exhibit 1 is tendered into evidence.
Objection.
And without objection, it's admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment has been read to you. You read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, and you are totally satisfied with the representation provided by your lawyer here. All of this is true. It states so help you God. State's Exhibit 1 is made a part of the record for all purposes. Is a pre-sentence report waived here?
Yes, sir.
Is there anything else to add? I'm going to make findings now. If nothing further to add by anyone, I'm going to find that Ms. Shipp, you are pleading guilty to this first degree felony of murder voluntarily, knowingly, intelligently. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, and you're totally satisfied with the representation provided by your lawyer. All of this is true, it states. So help you God, out of State's Exhibit 1, and the court supports those representations with positive findings that are in the record that state those admissions. I hereby find you guilty beyond a reasonable doubt of this first degree felony. I am following the agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 40 years. The judgment shall reflect an affirmative finding that a deadly weapon, namely a firearm, was used in the commission of this offense. Anything else we need to add on it? Is there any, nothing else from?
No, sir.
Anyone else?
Not today.
All right. Do you understand what has happened today, man?
Yes, sir.
Okay. That is all. We are in recess on this case.
Thank you, Judge.
Take Mr. Peterson, take Mr. Patterson's file too.
Before a few.
I don't know. It was the date that they also on July 1st, 2025. Mark on the file needs Spanish interpreter.
Entonces vamos a regresar el 1 de julio 2025 y también vamos a pedir para una intérprete de español.
Do we have a time, Your Honor?
El horario, señoría,
8:30.
8:30, 8:30.
Okay.
Okay.
All right, if there's nothing further.
Si no hay nada más, tenga buen día, señor, y buena suerte.
Gracias. Tengan un buen día.
Okay, thank you. Have a good day.
All right, let's call the city of Detroit, Ms. Harris. And Ms. Vivian, I think we're good. I appreciate you. Have a very good weekend, and we'll see you soon.
We seem to have lost Mr. Logan, Your Honor.
Lost who?
Mr. Logan.
All right, this is the city of Detroit, Ms. Harris versus Brandon Goodwin, case number SP 1484281. Count one, SP 1489877. SP 1594447. SP 1594761. SP 1672065. Mr. Goodwin, take your hat off, and good morning to you. State your name for the record. You're muted, sir.
Good morning, Brandon Goodwin.
All right, good morning to you. Ms. Harris?
Sherika Harris, standing in for Attorney of Record Vassal Johnson on behalf of Mr. Goodwin.
Okay, is that Corporal Spidell here?
Yes, Your Honor. Corporal Spidell, batch 402, Detroit Police Department.
Okay, good morning to you. Officer Franklin was here, Ms. Schneider, but he wanted to dismiss for no recollection. Then we have, who else? Officer Robertson. I haven't seen Officer Robertson either.
Hearing no response, defense will move to dismiss.
Okay. So, let me see these other tickets here. Franklin is dismissing for no recollection. That would be SP 159444472. And SP 1594761. The SP 167-20651. I didn't hear that officer. I don't see that officer in the room. We'll dismiss, grant that motion, dismiss no officer. Mr. Goodwin, an updated offer. Keep in mind, Mr. Goodwin, if you don't like the offer, today is the date time set for trial. But you're gonna break out home with Ms. Harris. She'll help you work it out. Join her home, please.
And Your Honor, I have to ask, are we just dealing with one matter?
Unregistered, untitled, and a no ops.
Okay, thank you.
We have Officer Williams and Spidell, so we have no ops and a no registration.
No ops and a no registration. Okay, thank you.
FTD unless he's compliant.
Is Officer Williams here?
Yes,
sir. Good morning.
Sorry, Officer Williams. Good morning to you. Can you state your name, badge number, and department you're representing?
Officer A. Williams, batch 3410, police officer for the city of Detroit.
Very good. Good morning to you. All right, we'll see what happens. We'll pass that matter. And Mr. Barry, are you ready on someone? Are you ready to go on someone else? Because the news did not show, right?
Correct, Your Honor.
He fell off. He fell off.
Yeah.
All right. What about Stephen Lamb? Mr. Lamb, can you hear me now? Mr. Lamb. He's not.
Lamb.
Lamb, yeah, Lamb. I've been calling you. You're at work, aren't you? Stephen Lamb? This device must not be set up right. All right, let's go down to Stephen Lamb, you there?
Stephen Lamb, yes. I'm trying to.
All right, City of Detroit.
I think you got me on mute.
City of Detroit versus Stephen Jerome Lamb, case number SP 169-8083, counts 1 and counts 2 and counts 3, SP 169-81011. Appearance for the record, please.
Oh, that's Barry Jr. on behalf of the defendant. State your full name, Mr. Lamb.
Yes.
State your name,
What's
sir.
going on here, bro? I'm trying to mute.
State your name. State your name.
Man, fuck.
All right. That's not your name, sir. Right. Check Brandon.
Thank you.
Can y'all hear me?
Yes. Yes.
Right.
We can hear you.
Hello?
Mr. Lamb?
Yes, sir. I'm sorry. Good morning.
Good morning. Let's also call SP 130-11371 into the record. Mr. Lamb, state your name for the record, please.
Stephen Lamb.
Today is the date and time. The one case is under warrant status. I'm going to enter not guilty plea on his behalf, give him a $0 bond. He has another case on a warrant status of old malicious destruction of property. He's going to have to go to Judge Stanford Jones for that. Mr. Lamb, I'm gonna put you in a breakout room with Mr. Berry. He's gonna get you an updated offer. Keep in mind, if you don't like the offer, you have an absolute right to a trial, okay?
Yes, sir.
All right. Join the room, please, Mr. Lamb.
All right. Yes, sir.
Mr.
Your Honor.
Pass the matter. So that other matter is a no insurance misdemeanor, Mr. Berry, but he has that, also has that malicious destruction of property. That's like 07 case.
Okay, but that's before another judge.
That's before Judge Stanford Jones. He has a warrant out, so you just want to advise him.
Yes, Your Honor.
Okay. Miss Harris, let's go back on the record with Mr. Goodwin. Miss Harris, Mr. Goodwin has a valid driver's license.
Your Honor, he also indicates that he provided his insurance and registration to the court this morning.
No, I mean I sent them to your office. I sent it to the attorney email.
You sent it to Attorney Johnson.
Yeah,
Are you able to just show it right now?
I don't have it. I'm out of town right now. I have a picture of it. That's the only thing I got of it.
Could you show us the picture, please?
I don't know how I'm gonna do that. I'm saying the picture on my phone.
Add it to the chat, Mr. Goodwin.
Okay, hold on. Just the registration or both?
Just the registration, please, and thank you.
All right. It's saying chat disabled.
Your Honor, do you want me to take him back into the breakout room?
Yes, please.
Okay.
All right, anyone else? Let's see. Trial. So Bush, I already let Bush go because Garrett never showed. Jasmine White, also Herman James Gordon never showed. John Graham never showed. Keith Griffin never showed. All these cases, probably a lot of them would have been dismissed if Burley came. Officer Burley, you're free to leave. Griffin never showed.
Yes, sir. Have a great day, sir.
Be safe.
Yes, sir. You too.
Have a good one. All right. We're getting down to the end.
Excuse me, Judge.
I'm getting you. I'm getting you. You missed the bus, Mr. Geary. So you gotta wait on the next bus.
They told me the 6th. I waited till the date. I remember my daughter's graduation from the Navy for that date.
Well, it said the 3rd on your sheet too.
He told me the 6th. That's what I had in my head.
Well, I got you. That's why you missed the bus.
She only had 2 court dates. That's why I remember. She said.
Yeah. That's why you missed the bus, though. You had the 6 in your head, but on the paper it said the 3rd. And you know this is the city of Detroit, and you know the buses don't run that good.
I know.
No, I'm gonna get you out of here. I'll get you and Mr. Loving. We're both. We'll get you out of here momentarily. Let me take care of Mr. Lewis. And
I'm being patient. I'm trying to be patient as I can.
I got you. I'm gonna get you out of here. Greer, I think you're on another date too. Let's see.
My paper states today at 8:30. I think it was just the time mix up.
Was that it? All right, we're back on the record with Mr. Lamb.
Yes, sir.
All right, let's go back on the record with Mr. Lamb. Mr. Lamb, I'm giving you an opportunity to speak to counsel. Counsel, what's your client want to do?
We seek a bench trial date, Your Honor.
All right, Mr. Lamb, I'm going to give you a trial date of July the 2nd, okay?
Yes, sir.
If it's nothing further, sir, at 9 a.m. If it's nothing further, have a very good day. Best of luck to you, okay?
Thank you, sir. You too.
All right, thank you. I'll tell you what, every time somebody misses their date, they swear that their paperwork says that the date that they actually are here. Every time. All right.
I'm not saying that. I'm saying what I heard. I'm not saying what I saw.
No, I wasn't talking about you, Mr. Gear. I didn't say that. Now I'm talking about everybody though. Mr. Greer said my paperwork says, and when you start out like that, it's almost like, okay, wait a minute.
I can show you.
All right, let's keep it moving. Let's call the city of Detroit versus Jamal Anthony Lewis, case number SP 119700501. Appearance for the record, please, Mr. Berry.
Elwood S. Berry Jr. on behalf of the defendant. State your full name, Mr. Lewis.
Jamal Anthony Lewis.
Good morning to you, sir. Corporal McCree, good morning to you. Can you put your name and badge number and department on the record, please? All right. Today is the date and time set for, good morning to you, Corporal McCree. Today is date and time set for a trial. Mr. Berry, give Mr. Lewis an updated offer. Keep in mind, if Mr. Lewis does not like the offer, he has an absolute right to a trial, all right?
Yes, Your Honor. I'm not finding him on docket.
Just one ticket number on the bottom of 9 o'clock, on the bottom of 9 o'clock, page 2. License improper.
Lewis is the name.
Yes, Jamal.
L-O-U-I-S.
L-O-U-I-S.
There, yes, thank you so much.
Join the room, please. Just pass the matter. Ms. Harris, are you ready? Ms. O'Neill, you keep coming back?
Hi, Your Honor. I just had
How
a
you
quick,
doing?
good. I just had a quick question. I know I had kind of asked the lawyer, but then I got a weird phone call from my insurance company. I just wanted to ask, does my ticket accumulate points by any chance?
No, not this one. You paid it already. We're gonna dismiss it.
Okay, thank you, sir. I don't know why they called in. Thank you.
No points, no abstraction.
Okay. All right. Thank you, sir.
Best of luck to you.
Thank you.
What happened to Miss Harris? Miss Harris, Mr. Goodwin is back. Are you ready?
I was trying to ask you, sir. I had got kicked out of the room by mistake, so I was trying to see if you could have put me back in the room with her. I don't know. I already sent her what she needed. I don't know if she ready or not though.
Just wait here then.
Okay.
Take a break. All right, let's do this. Are you ready, Miss Harris?
I believe so. I sent the court a copy of the registration.
Oh, we're waiting on you. This is we're back on the record with Mr. Goodwin. Very well. Well, that registration is expired.
Oh man, wait a minute.
I sent
Did
you
I
the
have
wrong
the
one.
date? You
That
probably
registration-
did.
Oh, sorry. Hold on. I sent you the wrong one.
Pass it.
No, okay.
My bad. Hold on.
Thank you. Thank you.
Okay, let's go with
I'll take the one.
let's call the City of Detroit versus Marvin Brewery, case number SD 5298081, SP 1115649, counts 1 and counts 2, SP 1142320, counts 1 and counts 2, SP 1568727, SP 4480-261, SB 851674, counts 1, 2, and 3. 2172-3273, counts 1 and counts 2. State of Michigan versus Marvin Greer, case number SX 27170. We'll strike that. SX 27170-321. Appearance for the record, please.
Erica Harris, on behalf of the defendant, please state your name.
Marvin Geary.
Geary. Okay. Day is the date and time set for we'll call it set for a show cause. It's actually set for the 24th. So he's early because he missed the bus on the 3rd. So we'll enter a not guilty plea on his behalf. We'll give him a $0. Now, here's another thing, Mr. Geary. Let me say this, and you don't have to comment. You don't have to. All right. So every time somebody comes in the driver's seat of a vehicle,
I'm so quiet.
There he goes. There he goes. Every time they say, either one, I'm just here because the kids were in the house, it was too loud. 2, wait a minute, he's getting out now. 2, they say, oh, I'm just sitting in the car charging my phone. I'm not driving. I'm not going anywhere. One of the 2. All right. Ms. Harris, speak to Mr. Geary. Oh, you don't have the allegations. I do see that he owes $288 on a no insurance proof. That's the only thing I can see that's affecting his driver's license. You can get him an updated offer. I can give you, all of them are either license suspended, no insurance misdemeanor, or unregistered untitled. He has one old expired plate, and then he has the no insurance proof. I'm gonna put you in a breakout room with Ms. Harris. She's gonna talk to you about it, and let us know what you wanna do when you come out. You have an absolute right to a trial.
Okay.
Join the room, please.
Your Honor, for Mr. Goodwin, could you tell me the date, the date?
Well, that's a super old ticket he's talking about. On that one ticket. Let's pass the matter on. So the one that he's looking to, it's not that super old. It's 8103.
23?
No, let's see. You're referencing the registration ticket, right?
Yes.
It's a 2023 ticket. I know it's a 2023 ticket. It may have been written at the same time as the other, but it's a 2023 ticket. All right.
Okay. Mr. Goodwin, as soon as you find the updated one, if you could send it to me, it would be appreciated.
Okay, I'm checking now.
Go in the breakout room, speak with Mr. Geary. All right, let's go past that matter. Let's go back on the record with Mr. Lewis. Mr. Lewis, I've given you an opportunity to speak to counsel. Counsel, what's your client want to do?
Your Honor, my client would avail himself of the people's current offer to enter a plea to failure to display.
You want to do that, sir?
Yes, sir.
Can you raise your right hand, please? Do you swear or affirm to tell the truth, whole truth, nothing but the truth?
Yes.
All right, you can put your hand down. You understand the maximum possible penalty for this offense is 93 days in jail and or $500 in fines?
Yes.
You understand that you have an absolute right to a trial?
Yes.
Mr. Berry went over your other advisor rights in the breakout room, did he not?
Yes, he did.
Took those rights?
Yes.
Have any questions about those rights?
No.
You know, by taking the deal, you're gonna give those rights up?
Yes.
Has anybody offered you anything other than what's been stated in the record?
No.
Let me draw your attention back to May the 6th, 2021 at around 4:52 p.m. in the city of Detroit in the area of French Grove and Gratiot. Did you have an occasion on that day to come in contact with the Detroit Police Department?
I believe so. Yes.
You can't believe, you gotta really know.
But yes.
Did you? Did you? It says you were operating a 2016 Ford. Does that refresh your recollection?
Was it a Ford Fusion?
I don't know if it was a Ford Fusion or not, a gray Ford.
Yeah. Yeah.
Do you recall that day now?
Yes. I recall that car, but yeah, that's my car. That's me. Yeah, for sure. That was it.
Were you there? Were you recall that day?
Yeah, I kind of, I recall, I think I recall that day. I don't go on that side of town often, but I do recall that day. It was like a couple years, but I believe I know I got a ticket on like 2 times over there. So I believe that was one of the times.
You want to take it under a no contest plea, Mr. Berry, for lack of recollection?
Yes, Your Honor.
Do you have any, you don't have any, you won't have any, you don't have any opposition if the officer said he pulled you over that day, do you, Mr. Lewis?
What do you mean opposition? Any, like, if he disagree with it or something?
Would you disagree with that? If the officer said he pulled you over that day, would you disagree with that?
No, I wouldn't disagree with it.
All right, I'm gonna enter a no contest plea. The no contest plea is gonna be like it's gonna be treated the same as a guilty plea for purposes of sentencing. It's just that you don't have a recollection, all right? For lack of recollection. So stipulate to the face of the ticket as an active factual basis for that responsible plea on your client's behalf, for that guilty plea on your client's behalf, counsel.
So stipulated, Your Honor.
Stipulate probable cause for the dismissal of the other matter.
Yes, Your Honor. So stipulated.
Okay. $240, Mr. I'll find him guilty. Strike that. I'll enter no contest plea. Sentencing them to $240 fine. When can you pay it, Mr. Lewis?
Can you give me to the 27th of June to the end of this month to pay it?
I'll give you July 1st, 2025. Pay it at any DivDat kiosk in the city of Detroit. I'm told you can upload to DivDat app to your phone, or come on down to the courthouse and pay it in person. Those are the 2 best ways I can tell you to pay it. If there's nothing further, sir, have a very good day. Best of luck to you, okay?
All right, thank you. God bless.
Cortez Loving. This is another case, Mr. Berry, that's been a show cause. This is the city of Detroit versus Cortez Loving, case number SP 164-9276, counts 1, 2, and 3 of appearance for record, please, Mr. Berry.
Elwood S. Berry Jr. on behalf of the defendant. State your full name, Mr. Loving.
Cortez Gene Loving.
All right. Today is the day, we'll call the date and time set for a show cause. Mr. Loving indicates that he has proper documentation, but if he doesn't get him an updated offer, keep in mind, if you don't like the offer, Mr. Loving, we'll give you have an absolute right to a trial. Join the breakout room, please.
And the charges are, Your Honor?
Oh, I'm sorry. The charges are improper plates, no insurance, and unregistered untitled. All misdemeanors.
Improper plates, no registration, and
unregistered untitled.
Okay. Okay.
We'll pass them.
Thank you.
Ms. Harris, are you ready on somebody?
Ready on Mr. Geary?
Geary, let's go back on the record with Mr. Geary. Mr. Geary, I've given you an opportunity to speak to council. Council, what's your plan want to do?
Your Honor, we're respectfully requesting a pretrial date.
All right, I'm going to give you a pretrial date, Mr. Geary, of July 1st, 2025 at 8:30, okay?
Yes, sir. Thank you.
That's got back behind the wheel of that car again, too. Yeah, run his license. Run his license, please. All right, have a good day, Mr. Geary. Have a good day, sir.
This one was supposed to be used.
He's already fled.
Okay.
This is the city of Detroit versus Kawhi Gear. This is the one I was saying that everybody says that. My thing says today. Mr. Greer, are you there?
Yes, sir.
Turn your camera on, sir. Let me see. Mine said today. Good morning to you. Let's see that notice. Let's see that notice that you said it said today.
Well,
So
I did just kind of get the warrants list.
What does it say here? Let me see. What does that date say on there?
6/5/25.
Isn't today Friday? It say Thursday.
6/5/2025. He said mine said today. He doesn't know what day it is.
I'm sorry, I am tired from work.
Right? That's what I told you. It happens all the time. It's mine. That young lady came in here the other day. I'm supposed to be here, Judge, at 1 o'clock. Well, she was still late if she had to be here at 1 o'clock. But then she holds the notice up to the screen, and I'm looking, I say 9 a.m. It's exactly the time it said on the thing. But it's always wrong. See a trade versus give me the correct pronunciation of first name, sir. Quay Greer, case number C4-861821U798333811. Appearance for the record, please.
Quay Greer.
Erica Harris on behalf of Mr. Greer.
All right, we're here because of money.
Give me a couple more weeks and I'll definitely have it paid off. I get paid on the 18th, so I should be able to pay this ticket all the way off then.
You owe 2 of them.
I can take care of one at a time. So the 18th and after that, it'll be July 2nd.
July 2nd for the both of them. You supervise your own payment plan, all right?
Okay.
All right, I'm gonna bring you back down to the 240, the original cost of the ticket. I'll do that. So bring down the 240. I don't know, the other ticket was something that you had before me, I think. Let's see.
I think you handled both matters. It was a driving without license, I believe.
I'm gonna bring you down. I'm gonna bring you back down to 240 on the other one as well. All right.
Okay.
All right, Mr. Greer, 240, pay it at any DivDat kiosk in the city of Detroit. I'm told you can upload to DivDat app to your phone, or come on down to the courthouse and pay it in person. 2 best ways I can tell you to pay it. Best of luck to you, sir. Have a very good rest of your day. All right.
Okay, you too. Thank you.
Thank you. All right. Ms. Harris, can you go and grab Ms. Gates out of breakout room 8? We're gonna have her back on what day was that? July the 11th. Please.
And you want her to come to the main session for that date, or does she already know that date?
No, she doesn't know the date. You can give her the date, and I think she's already lined up on how on the terms of the
Okay, July 11th, correct?
trial, yes.
Thank you.
And testing. Okay, Mr. Barry, are we ready on Mr. Loving?
Ready, Your Honor.
All right, let's go back on the record with Mr. Loving. Mr. Loving, giving you an opportunity to speak to counsel. Counsel, what's your client want to do?
Your Honor, my client has shown the valid registration and insurance, valid documents.
Mr. Loving, we'll dismiss the cases for providing valid documentation. Sir, best of luck to you. Have a very good rest of your day, all right?
Thank you, you too.
All right, take it easy. Be safe out there. Last but not least, Mr. Goodwin, let Ms. Harris come on back out. Right to. I think you can go online and see.
Yep, it's from the Secretary of State. I am looking at the bottom of the screen, so it does show that.
Let's go back on the record with Mr. Goodwin. If you think it's authentic, I don't have any problem proceeding.
I believe so, and I've provided a copy to Ms. Schneider as well.
I'll dismiss the cases for providing valid documentation. Best of luck to you. Have a very good rest of your day, all right?
Thank you. Appreciate it, sir.
All right, we'll go. Officer Spidell, be safe out there. Officer Williams, be safe. And what about Ms. Gates? She's gone.
Yes, Your Honor. Attorney Johnson had one other client, a Miss Garrett.
They never showed.
Is it possible we could put this matter over? I just want to be able to provide him with an update.
I'm just gonna go ahead and put a warrant.
And Your Honor, so he provided me with a notation. I just think that prior to him leaving, he may not have recognized that the officers were present. If the court would allow a
Told him that in a text message.
Your Honor, he's at his daughter's graduation, so I was trying to give him the benefit of the doubt. Can he come back on Monday?
No, it's not anything against, it's not anything against Attorney Johnson. It's his client didn't show. What did he do anyway? This is a pointed case and she didn't show. You know, these cases are sitting here getting super old, and let me see what she's done. But Yeah, it's October the 2nd that the case was initiated, scheduled for arraignment on October the 2nd, October the 20th. Scheduled for pretrial. No, this is two years ago, and she continues to miss. She had a bench warrant. Another show cause hearing on failure to appear bench warrant. $0 bond. All right, that's it. I think that'll take care of everything.
Proof of employment within 30 days, no employment as a home health care with minors, field visits 1 time per month for 3 months, TAP evaluation out of custody, 20 sober meetings in 20 days, 120 hours of community service restitution. If he completes his GED or obtains some higher level education or trade school or joins the military, the community service hours we deem satisfied, the aggressive driving course, and he'll provide you his certificate showing that he's completed that. Probation, is there anything else?
No, Your Honor.
Is there anything else you need from the court in order to be successful? Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court to appeal. And also, as a part of your agreement, the court will be taking into consideration 2024 CC 736447. Counsel, some misdemeanor courts, I don't know which ones anymore because they're different ones. They don't want you to sign their dismissals. So legally, could I sign it? Yes, but I don't like to unnecessarily throw weight around. So,
I don't think it'll be an issue.
all right, thank you. All right, probation, he said that he's going to be positive for marijuana. So if you'll test for levels. All right, if you ever need anything, just let your probation officer know. If you feel they're not addressing it, you can always come back to me and address it with me, understand?
Yes.
And if you want to go in the military, go over there, let them know that there will be no objections from the state, and I'm sure your defense counsel won't object, that I will terminate you early once you've officially signed up with them. That's been done before in this court, okay? All right, thank you. You're welcome. And your client is here.
I'll do it probation.
All right, yes, okay.
I don't know if the paperwork can get done.
I think we're trying around to get the paperwork on this case. I was gonna send it, we sent out next April fee.
All right, and what type of case is this?
This is Christopher Close.
Well, I tell you what, counsel, if possible, when we take a break, or if you're able to do it over a break, but it'd have to be in the afternoon.
I'll try.
All right, so we'll see if he can. If he can, he can.
Okay.
Okay. All right, and you, sir, what's your name? On the back row?
Thomas Simpson.
All right, so how old are you? All right, when you are asked to come over to the court, you come to the court. Do you understand? Now you're 21, so maybe you don't understand things. So let me tell you the consequences of certain things, right? If I order you to be here for court, you need to be here. And guess what? When you say you're not coming, all I do is send an order to the deputies to bring you over. And if there is a disagreement between you and the deputies about appearing in court, who do you think is going to win that argument? Yeah, so you had better start making better choices because you're in felony court. Sometimes people feel like 21-year-olds are not fully aware of consequences, but you have to be quick in being fully aware of consequences because you're in felony court. Do you understand? All right. All right, so do you all have your witness?
Yes, I believe he's back. You want him on the stand, Your Honor?
Yes.
Also, Your Honor, we have an intern from my office here. She wants to know if she could sit in the bench to observe.
Yes, hi. What's your name?
Allison Greenman.
Oh, welcome. You can, of course, come down anytime and join us. And so, is there a disagreement on whether or not this person is the actual outcry?
No, Your Honor.
Okay, all right, then this should be short. We'll bring them in and take testimony. Hello, if you'll take a seat here, please. And we are back on the record.
I need to try and find something.
Okay, just have a seat. Okay.
Oh, sure.
Oh, there, Lorraine's client is gonna be a police, so we'll need to hold him for the afternoon. Mhm. Okay, all right, so we'll, all right.
Can I get your name?
Eric Mata
You're on KFC.
with the K.
Can you put that microphone on, the little bitty one? Yeah.
Just come in right now, Your Honor.
Oh, thank you.
We did great.
He's on the stand.
All right, we're on the record. And this is the outcry hearing and defense. It's the court's understanding that you all agree that this witness that is on the stand, and what is your name?
Eric Mata.
Eric Mata is the actual outcry witness?
Yes, Your Honor.
All right, could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand, state your name for the record.
Eric Mata.
All right, you may proceed.
Thank you, Your Honor. Eric, with respect to when your forensic interview took place, do you happen to know when that was?
It was in 2023. I don't have an exact date. I'm sorry.
No worries. But you were above the age of 18?
I was, yes.
And she was below the age of 18?
Yes, she was.
And of course, just for clarity's sake, where did the forensic interview take place?
It occurred in Child Safe in San Antonio.
Is that your place of employment?
Yes,
Are you a forensic interviewer?
I am.
How long have you been one for?
I've been forensic interviewing since 2000 and the end of 2017.
And do you know why we're here today?
Yeah, for a criminal trial against the defendant, Mr. Rodriguez.
And did you have a forensic interview with Emily Rodriguez?
Yes,
And in preparation for today, did you have a chance to review that forensic interview?
I did.
And we had briefly spoken just about logistics in getting here yesterday, correct?
Correct.
Now, with respect to your forensic interview with Emily, kind of how did that start?
So anytime a forensic interview is conducted, it's through the request of the investigative party. I don't recall which specific investigative party it was. I know it was either CPS or Bexar County investigator. One of them requested the forensic interview, and we moved forward with it as me as a forensic interviewer.
So when you say you move forward with it, you're talking about moving forward with the actual conducting of the forensic interview.
Right, scheduling and having the family come in and doing the interview and providing services.
So when you're in the room with Emily, how did things start?
In the interview room?
Mhm.
So anytime we begin a forensic interview, we don't really talk about why they're there right away. We'll spend a few minutes just building rapport and getting to know each other a little bit, just to make sure that she's comfortable in the room with me. Once we did a few minutes of that, we went over something that we refer to as an event narrative practice. And the event narrative practice is just a way for the interviewer to gauge the interviewee's developmental level and just to make sure that they're able to give a sequence of events from beginning to end.
And did you kind of take those normal steps and processes with Emily?
Yes.
And after that, were you able to get into kind of the incidents or acts that occurred?
So after the event narrative practice, we do what we refer to as some truth. I'm sorry, we go over some rules in the room. After we went over the rules in the room, we went over what it means to tell the truth, what it means to tell a lie. And then she promised to only talk about the truth, and then we talked about why she was there.
So she affirmed the nature of understanding what's a truth and what's a lie.
That's right.
And that's common practice.
Yes.
So after that, what happened next?
We went into the substantive portion of the interview, which is where we discussed the alleged abuse.
And with respect to the things she was able to articulate, what was Emily able to tell you? Just what was the first thing you remember her letting you know?
We talked about 3 separate incidents of, in her words, her being molested by her father. We talked about the first incident where he molested her. We talked about the last incident where he molested her. And then we talked about the most memorable incident where she was molested by him.
And with respect to the first, what was she able to communicate to you?
With the first incident, she told me it happened when she was 6 years old. It happened in every incident happened in the defendant's bedroom. She said that she woke up to him touching her breasts, and then she clarified that it wasn't really her breasts because she was kind of too young at that time. She was only 6 years old. So she clarified he was more touching her nipples. After he touched her nipples, she talked about how he dropped her pants and her underwear, and he was putting first his penis, kind of in her words, in her crack, and then eventually, after his penis touching her crack, he penetrated her anus. She talked about how she was really scared and she didn't really know what to do. The only reason why it stopped was because she yelped, and I guess that tipped him off that she might have been awake, and so he stopped at that point.
And what about that was with respect to the first, what about the most memorable?
She talked about
All right, let's try those 2 cases.
Yes, Your Honor.
Colby Sullivan, do you want to take up? Let's see, we'll take up Curtis Dixon. On the record in 2025 TR 91, State of Kansas versus Curtis Dixon. This matter comes on for status hearing. The state appearing by Assistant County Attorney Paul E. Dean and the defendant appearing in person and pro se. Mr. Dixon, you do not have an attorney. Are you going to get one?
Yes, Your Honor. I was wondering if I could have another 30 to 45 days. I start a new job next week, and I was wondering if I could have that amount of time to acquire an attorney.
What efforts have you made to obtain an attorney so far?
So far, I haven't made any. I haven't had any funds at all to retain one.
Did you apply for an attorney?
Yes, I did.
You were ordered to fill out an application. Did you do that?
Yes, I filled out the application the day you told me to do it and turned it in.
All right. And let me see what we found on that. You were denied, is that right? Well, I am not seeing the application.
I checked on at the courthouse and they said they couldn't find it.
No,
okay.
I'm not seeing it.
Judge, that's the one I talked to you about.
Oh, with the, you said he had a check and
there was a check stub attached to it.
And then you told him to send in another one. Did you send in the second one?
No, I did not.
All right. Well, if you had, we could have been moving along. All right. So have I asked you any questions about attorney, or did I just tell you to send in the application?
You told me to send in the application.
All right. Well, let me try to see what I can find out right now. Where do you work?
C&G drilling.
C&G drilling?
C&G, yes.
And what do you get paid per month doing that?
Right now, 1,500 to 2,000,
So,
maybe.
so average about 1,750 if it's between those two.
Probably.
And are you married or single?
Single.
Do you have any children, minor children you support?
No, I do not.
And do you pay any kind of rent or mortgage?
Yeah, I pay a rent here at this house.
How much per month?
800.
And then do you pay any kind of utilities in addition to that?
No, that's utilities included.
Do you have any kind of automobile payments?
Yes, I do.
How much per month?
About 200.
You have other expenses, other bills besides your living expenses?
No, ma'am.
But you do have to pay food, clothing, personal items, gasoline, things of that sort?
Yes, ma'am.
All right. I will appoint Attorney Richard Paw.
Okay.
He will be on here at 10, but he'll probably want you to call his office. Can I give you that number?
Yes.
It's 316-303-0100. Please call him as soon as possible. And Missy, when do you want to reset this?
Let's set this for July 18th at 10.
Okay, be back here by Zoom with Mr. Paul, July 18th at 10 a.m. And I believe you are on bond. We will continue. Let me double check that too. Interlock and insurance. Okay. Looks like you posted a $2,500 recognizance bond on April 29th, 25, and I will continue that with all the conditions existing plus the added that you call Richard Paw today in the afternoon and that you reappear with him by Zoom July 18th at 10 a.m. Any questions about that, Mr. Dixon?
No, Your Honor. I will do that today.
Okay, thank you. Anything further, Mr. Dean?
No, Your Honor.
All right, then thank you, Mr. Dixon. You are released from today's proceedings. And we will now be on the record in 25 TR 49, State of Kansas versus Colby Sullivan. County Attorney Paul E. Dean for the state, and Mr. Sullivan appears in person and pro se. Mr. Sullivan was having a similar problem as Mr. Dixon trying to get his application here. He said he sent it 4 times, but who knows where these were going for a while. You went to Butler County. Did you have some grief getting that Mr. Sullivan over there at Butler?
Just a little bit, but they went ahead and did it.
No.
My employment status has changed as of about 30 seconds ago.
Oh no, what happened?
I was let go. They let go 30 people today.
Oh my goodness. So is this application current?
Yes, I just updated it because I was in the process of filling it out when I got the phone call from my GM. But I do have a job interview this afternoon.
Okay, good. What was the company? TGC
Group.
Group.
It's a subsidiary of Marriott.
Okay. All right, but you think you'll get another one soon?
Yes, ma'am. I'll probably have one by the end of the day.
Okay. Well, what were you making per month? Oh,
Per month with TGC, I was making about 3,200 a month.
married or single?
Single.
Do you pay, support any minor children?
I have my 2 kids living with me.
So you're a family of 3?
Yes, ma'am.
Now, these 2 kids living with you, are they your children or you're just supporting them for someone else?
No, they are my children.
Okay, very good. All right. And then you pay rent or a mortgage?
Rent is $1,250 a month.
Okay. And then do you pay utilities on top of that?
Yes, ma'am. They fluctuate between $300 and $450 a month.
Okay. Pay an automobile payment?
No, ma'am.
Okay.
I
Any
do not
other?
own a vehicle.
Okay. Any other payments that you have to make regularly? Insurance, anything of that sort?
No. I got my medical insurance that I pay for myself.
Okay,
And that's
what do you pay?
that's $150 a month.
Okay. Well, I am going to appoint Attorney Richard Paw He'll be on here shortly, but I think he'll probably want you to call his office so he can get the files and talk to you after he gets those. I can give you his number. Are you able to take that down?
Is it the 303-1010 or 00?
0100.
Yes, ma'am.
Okay. All right. And let's give you a new court day. Missy, when do you want him to come back?
July 18th at 10.
July 18th at 10 a.m. So make sure you try to get a hold of Mr. Paw's office today. Not this morning because he'll be over here. But I always say the day that I appoint, and then, or at least within the next couple of days, and then be ready to go on your case and reappear July 18th at 10 a.m.
Yes, ma'am. Thank you, ma'am.
You are welcome. And let me take a look at your bond. I will continue that April 29th bond that you posted for $2,500. Oh, that's Scott Dixon. I'm sorry. Let me switch screens. I will continue the $7,500 bond surety that you posted on February 1st, 2025. And I will remind you that you need to follow all the existing conditions. Do not possess or consume any alcohol or illegal drugs or be around any places where that's available or being used. Make sure that you don't drive unless you're licensed and legally able to do that, including if you're required to have an ignition interlock device. And then the added conditions are to contact Mr. Paw and reappear by Zoom July 18th at 10 a.m. Any questions, Mr. Sullivan?
No, ma'am.
Mr. Dean, anything further from the state?
No, Your Honor.
All right, then you may go, Mr. Sullivan.
Thank you, ma'am.
You're welcome. And I think the rest of these are Mr. Paw's. That's a 10 o'clock docket. Is there anyone here that is not represented by Mr. Paw? And I think he said something about he may be running late today, but he's getting a new associate that hopefully won't be running late as much in the future.
Yes, Your Honor. Fortunately, there's only 3 cases. It looks like maybe 4 cases, but one of them just looks like a balanced status. So we should be able to work through this fairly quickly. He did send me a text, and apparently that case is dragging along. So I think all we could do is probably go into recess at this point in time. And then if we get people showing up early for the 11 o'clock, I suggest we start taking those. And we'll
Okay, I'm
try to
going to
get,
do a little inventory of who is here. So you may leave the screen if you want, but I'm going to take a little bit of attendance here. Is Zach Ashlock here?
and I don't think we've had any contact. I don't think there's been any contact from him since the last court date, Your Honor.
No. Well, you're supposed to apply for diversion, but it apparently hasn't been granted. How about Julio Cesar Gallegos Oliveras? Is he
Yeah,
here?
Judge, he's the one in the jail.
Okay, thank you.
And I believe Miss Garcia is probably interpreting.
That is correct.
Okay, with an interpreter. Thomas Davis.
Present,
is
Your
here.
Honor.
Thank you. And then we've taken care of Mr. Dixon. How about Albert Ryherd? He's supposed to have an attorney, Mr. Garcia. What's the
Yeah,
status?
that's correct. That's not Mr. Fall's case. That was we'll check with Mr. Garcia. I don't see him on here. Let's see, I'll check on that, Your Honor, while you're checking on the balance.
Okay. And do we have, okay, we've taken care of Colby Sullivan. David Warden? David Warden? Okay, then we go into 11 o'clock. Who's the gentleman at the Greenwood County Courthouse? What's your name, sir? You'd come up and tell me? You, what is your name? If you'll need to come up to the microphone so I can hear you, sir. You're gonna have to come up to the microphone. Can you see if he needs an interpreter, Miss Garcia?
Señor, ¿necesita usted intérprete? I don't know where the microphone is.
Oh, okay.
All right. I'm just
Okay,
here
what
to support
is your name?
Juvenal Olivares.
Miss Garcia, what is he saying?
He
He
said
said it's
Reinaldo Olivares.
Juvenal.
Bernal.
Olivares.
I'm not understanding what he's telling
¿Y
me.
qué es lo que quiere decir?
Yo nomás estoy aquí por Julio.
I'm just here for Julio.
You're just watching?
¿Solo está observando?
Sí.
Yes.
Okay. All right, then I'll let you go back and have a seat, sir. Thank you.
Puede volver a regresar a tomar asiento. Gracias.
Judge, I'm gonna work on some journal entries off screen while we wait. As
All right,
Paul
thank you.
indicated, he was entering the last plea and sentencing, so hopefully it's not too much longer.
Very good. Missy, do you know if any of the 11 o'clocks have been diverted or paid? You had a chance to look at that? Oh, we have a try.
I haven't today. I will look and see.
Well, I can do that too. Chad Bream is set for trial, isn't he? Where did he go?
Yes.
Is that 11 o'clock? Yes, okay. Well, where did I lose them? Hmm. Hmm.
I guess we only have one payer peer left, and he has not paid. And then I don't see that any of the diversions that are left have
Diverted.
filed.
Okay.
Yeah, they haven't diverted. And then one's a revocation.
Which one is that?
Liliana Gutierrez.
Missy, could you forward? I just sent Mr. Garcia an email that his client has not paid nor appeared, and asked if he could join, but I didn't include the link. I don't know whether he was included with the link previously. If not, could you send him the Zoom link?
Who was it?
Vincent Garcia, that's the attorney of record for Albert Reihard. I don't
Oh
see
yeah,
it.
I sent it to him Wednesday.
Well, I just sent him, asked him to join because no one's paid and no one's appeared.
Okay.
Although usually on those payer appears, I release the attorney.
But he hired that attorney.
Oh, he hired that attorney. Okay, okay.
Privately hired, and he's still in the case.
That's a different story.
But I'll resend that link to him.
Double check here, make sure but he wasn't released on the journal entry. No. Defense counsel motion withdrawal box is not marked.
Okay, I had a Matthew Reed. Is he the one that paid? At 11, he's the last one on my 11, but he's not on the screen.
Look here. Yes.
Okay, paid. Then you've added a couple to me.
No.
No?
No.
Oh, this is that one when I printed it yesterday. It did that page thing. Okay.
Oh, it didn't print them all out.
Okay. Well, folks, we are going to take just a few, I don't know how long a recess until you see Attorney Richard Paul pop up here, and then we'll be ready to go. So thank you all for your patience.
So Misty, could you go through on the payer peers? Okay, so Bream is a trial. Lillian Gutierrez, she paid.
No, she was a diversion revocation.
Oh, okay.
We still have one that did not pay.
Is that the Ethan Leach? Okay.
Yes. And then all them diversions that are still left on the docket, I don't show anything
Right.
filed yet. So, and then one bench trial.
Okay. Thank you.